We'll go on the record in People versus Sean Hackney. This is file number 256807. If I could have counsel put your appearances on.
Record Your Honor, my girl got the people.
On behalf of Sean Hackney.
All right. I can't see behind that TV. Mr. Blumberg, is there anybody else seated over that way? Okay, thanks. All right. This hearing was set for 1:30. It's now 1:35. Mr. Hackney is not present either by video or here in person. Mr. Brown, have you had any contact with Mr. Hackney?
I have not, Your Honor. The last contact I had with him was our last hearing. My further attempts, he apparently does not have a voicemail. It's one of these, the wireless customer is not available and I can't leave a voicemail, not responding to any text, not responding to an email. I did call his, what I guess was his fiance or ex-fiance at this time, which was another number he gave me. She essentially has had some issues she's trying to work out with him and has not had contact with him either. That is honestly all I have for the court.
All right, thank you. This was set for a review hearing today to monitor restitution payments. The last hearing we had was in November. I believe Mr. Hackney had made a small payment at that time. I did check with the clerk. She indicated that no further restitution payments had been made since November. So number one, Mr. Hackney is still on probation. Is that right, Ms. Davis, I believe?
I believe it wasn't discharged, Judge, because of the outstanding restitution. And I do have some additional restitution information for the court.
Okay, yeah, if you want to make a record of that.
At the balance that was due and owing as of October 29, 2025 was $4,150. Back on November 5th, 2025, Mr. Hackney made a payment of $146. Other than that, even though he indicated that at that time he was working, would make that payment every 2 weeks, he made no additional payments.
Okay. So, Ms. Davis, I would just request that Mr. Brunical prepare a bench warrant for probation violation for failure to pay restitution. I'd also indicate for the record that the court, at the time of sentencing, imposed 9 months. The court held that time in abeyance for the primary purpose of giving Mr. Hackney an opportunity to make restitution payments for the benefit of the victim in this case. And I believe I stated at that time to Mr. Hackney on the record that that was really the only reason why I wasn't imposing jail time at the time of sentence. So in light of the fact that Mr. Hackney is not paying his restitution, we will proceed on the probation violation, but the court's intent with the time that he's arrested would be to impose that 9 months of sentence. And but we can make further record of that at the time. And that's all on that file. Mr. Brown, did you have anything further on that case?
No, Your Honor, thank you.
Mr.
Did you want the bench warrant to also include his failure to appear to court today?
Yes, yeah. Thank you. Okay, Mr. Blumberg, I know we're early. Were you ready with your client? Okay. Ms. Willie, if you'd like to come forward, please. We'll go on the record in People versus Aubrey Willie, file number 256879. The record should reflect Ms. Willie's present here in the courtroom today. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record, my phone has peaceful.
Good afternoon, Judge Elliott Blumberg on behalf of defendant Aubrey Willie.
Ms. Willie, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Blumberg about that? Okay. Mr. Blumberg, are there any additions, deletions, or corrections?
There are none.
Any challenges to the scoring?
No, Judge.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
You asked that any order of courts when you impose should include, of course, the restitution of family term amount of $460.46 that may have already been paid. I don't know. I don't have confirmation on that yet. If not, we asked that it be paid. This is a situation where in the PSI there was a reference to the possibility of court imposing deferral under NCL 333.7411. I have copies of the statutes and I've done the research on the matter as well. As the court's well aware, 7411 deferral applies to use or possession of controlled substances under the Public Health Code in violations of section 333.7403 or 7404. This is neither of those. This is under 333.7407. So it's not one of the specifically enumerated sections of the statute for which I believe 7411 can be granted. Thank you.
Judge, we have I'm sorry.
Sure, go ahead.
We have a different view of that. 337403 talks about knowingly or intentionally possessing controlled substances or prescription forms. We believe that, I thought I had sent to Mr. Rolo the citation that allowed 7411 status for someone who commits the crime that she's been convicted of. The statute itself specifically refers to prescription forms. So it should be treated just as a possession charge.
Okay, I'm just gonna take a short recess. I want to take a look at that statute.
Sure, can I just give you what I?
Absolutely.
Sure. All rise.
Okay, we're back on the record in People versus Willie. I had a chance to look at the 7411 statute, and so under 333.7411.1, there's essentially three requirements. Number one, defendant must have no previous convictions. Number two, well, the third one is the defendant must consent. The one that's at issue here, though, is number two. The defendant must have been found guilty of an enumerated offense, and 7411.1 lists the enumerated offenses, and that is guilty under 7403 2A5, 7403 2B, C, or D. Use of a controlled substance under 7404, or possession or use of an imitation controlled substance under 7341 for a second time. So 7411 eligibility is limited to a finding of guilt as to those offenses. In this case, Ms. Willie's entered pleas under 7407, which is not an enumerated offense. So I find that she would not be eligible for 7411, having pled guilty to those offenses. So Mr. Blumberg, I don't know if you want to go back to the drawing board with Mr. Rolla. I mean, I would give you an opportunity to try and renegotiate a plea to a different charge.
Judge, if you don't mind, I'm just, the statute that I handed you, those offenses in the statute, those would be covered under 7411, would they not?
What you highlighted was 7403.1.
Yeah.
And that is not one of the enumerated offenses.
No, I understand. But my question is, those offenses that are listed before the reference to a prescription, are those covered? Is it the court's view those are covered under the statute? Is it possession with someone who knowingly possesses a controlled substance?
So under 7403, according to 7411 sub 1, the offenses that are eligible would be 7403 2A5, which is possession less than 25 grams of a number of different substances. That does not include the prescription form. 7403 2B, C, or D. That includes a number of different types of controlled substances. Or a prescription form. But none of those crimes involve what Ms. Willie's entered a guilty plea to, which is obtaining a controlled substance by fraud. So
Yeah, but that's a prescription form.
okay, I'm just saying what she pled guilty to, the statute she pled guilty to, are not crimes that are eligible under 7411.
Okay. I certainly don't want to delay sentencing because I am hoping the court will, if not grant 7411, give us the opportunity to supplement with a brief that I think would perhaps change the court's view on that.
I mean, you can, but the statute's very clear about what crimes a person has to be found guilty of to qualify under 7411. And 7407 1C, which is what she entered her pleas to, are not listed. So
And now I understand more fully further discussions with Mr. Rolla.
I intend on following the recommendation. I don't know if that helps.
It does.
I'm not planning on sentencing Miss Willie to jail today. My intent is to hold jail time in advance.
And that would be fine, I think, and appropriate. And if I were able to support our position that apparently I'm not able to do at the moment, would the court then post-sentencing consider amending the sentence to include 7411 status?
I would. I mean, I'd be happy to consider anything that you wanted to file afterwards.
Okay.
So,
And that's fine. I think we're prepared to move forward then.
Ms. Davis, I mean, what's your understanding of
I
this?
mean, I think that it's not part of the plea. I know that she's been medical, where she works in medical capacity. She has nothing on her prior record. That is why I recommended 7411. When I read it, you know, it's kind of broader, so
Okay.
that's why, you know, I left it up to you all to argue it in court on whether or not
Okay,
it's fell under that category.
all right. So again, what I'm seeing today, I don't think she is, but I'm happy to consider.
I appreciate
motion
that.
Later.
I thank you.
Okay. I mean, generally, I'm in favor of allowing HIDA and 7411 where eligible, because I don't generally think there's any risk to the community in giving a person that opportunity, so. But I can't just ignore the statute.
And I know that, Judge. I saw that statute and it made reference to possession of certain substances and prescription form. So, and that was the basis for her to obtain the Adderall through a fraudulent means.
Right, yeah, and if 7411 allows that kind of interpretation, then maybe it does, then I think.
I will delve further. I appreciate the opportunity.
Okay, all right, so other than that, I don't know where we ended here. Did I inquire of you about the guidelines?
Oh, I'm sorry, Mr. Rowland just gave the court the prosecutor's elocution.
Oh, that's right, okay. Mr. Blumberg, your allocation.
Thanks, Judge. And I want to thank Ms. Davis for the thorough PSI that she prepared. We haven't always seen eye to eye in the past, but I think she gave some thought to this, and I appreciate her recommendation because I think it's appropriate for a number of reasons. One of which is my client has no prior criminal record. She has obtained an associate's degree and is attempting to better herself professionally. She acknowledges her wrongdoing, and I know you'll give her the opportunity so that she can explain how remorseful she is about what had happened. But this really is sort of an offshoot to a condition that she has and has had, a mental disorder that had been treated and continues to be treated, unfortunately with Adderall, which one of the side effects of the drug that she's been on for a fairly long time, it creates impulse behavior issues where the Adderall that she wrote the prescriptions for, she actually is prescribed that. And she was going through a real decline in her mental health for a number of other reasons. And so she panicked and thought that she would need more Adderall when the need came. And she acted impulsively, and she will tell the court how sorry she is about that. You know, it's cost her career in the health field. She understands that. And that's regrettable because that's where her training's at, but she's prepared to move on. And if the court were in fact to give her the opportunity to prove to the court that one, incarceration isn't necessary, but she is a member of our community that provides other services. And so I know she has the support of her family. Her mother and stepfather are here today showing their support. So we hope that the court follows the recommendation, at least as it relates to no immediate imposition of jail time. I think a period of probation would be appropriate. And certainly the amount of restitution that the prosecutors suggested is, we'll take care of that.
Thank you. Ms. Willie, anything you wanted to say today?
Yes, I wrote it down if you don't mind. I also want to thank you for your time today, more specifically because I appreciate it being able to speak. I am very deeply remorseful for my actions that have brought me here. I take full responsibility for what I have done. I know that I have done wrong. I was diagnosed with ADHD and medicated as a young child all the way up until in my 30s. Recently, I was diagnosed with post-traumatic stress disorder, major depressive disorder, and anxiety disorder in 2020, which I really struggled to come to terms with over the last few years. After so much trial and error with all these different medications, antipsychotics and depression medications, it clouded my judgment. I got into car accidents. I had problems trying to find the light. However, since then, I found myself in a really dark place with my mental health. But since then, with counseling, holistic practices, and a lot of meditation and looking within, I have gained control over any reliance on Adderall. I'm actually, or any medications. I'm off all of my medications, and my control in my life has been clearer than it's ever been since I was 7 when I started medications. I see things clearer than I ever have. I am an active wife and an active mother, a daughter. and a law-abiding member of our community. And I am incredibly sorry for the havoc that I've caused, not only upon the court, but upon my own life. I am prepared to move on. I've already moved on and found a medical job that does not have anything to do with prescriptions or anything out of that. It's more using my mind to help people holistically. And I really do appreciate the time and the opportunity to speak on my own behalf today, sir. And I also want to thank Cindy over here, because she was very kind to me when I went to go meet her. This is all very new to me. So everyone's been very kind, and I am very appreciative.
Okay,
Thank you,
thank
sir.
Ms. Willie, I did read through the pre-sentence report, so I'm familiar with what happened in this particular case. I'm also familiar with you and your circumstances and your background based on the information in that report. And I take all of that into consideration, along with what the lawyers have had to say and what you've had to say here. Number one, I think there are some factors here that certainly work in your favor, your lack of any kind of prior criminal history. And this isn't a violent offense. This isn't an offense where there's a per se, a victim outside of a monetary loss. And I can appreciate that, you had some issues going on that may have contributed to your behavior here and lack of good judgment, that you clearly failed to exercise good judgment in this circumstance. I don't know that that's an excuse, and I don't know that you're using it as an excuse, because there's a lot of people that suffer from those conditions that don't do things like this. So you still have a responsibility, particularly somebody who was in your position with access to the kind of things that you had access to. And as I'm sure you're aware, that public trust is a really important part of that. And so when you betray that, there is a harm that goes beyond just what you did, and it undermines trust in that system. All that being said, I do think, as I've indicated earlier, that the recommendation is appropriate. I think it addresses rehabilitation going forward, provides some supervision to make sure that you're on the right track, you're staying on the right track. I am going to impose some jail time. I'm going to hold that in abeyance, because I think in your case, the rehabilitation aspect of this is more important at this stage than incarceration is. I don't find that is something that would benefit the community at this point. I do want to caution you, though, that if you do fail to comply with your probation, and that includes paying restitution and fines and costs, that I can impose any or all of that jail time immediately up front, because I'm holding it in abeyance. And I think you were here when the previous gentleman who didn't appear for court and wasn't complying with paying his restitution, I held his time in abeyance, and he had an opportunity to avoid going to jail, and now he's going to go to jail for 9 months once he's arrested. So again, I'm going to caution you not to think that time isn't out there, because it's not being imposed today.
Yes, sir.
So I'm hoping that will provide an added motivation to you to comply with your probation. And if you do, we'll sign a discharge in a year, or maybe even less if you do well. And you won't ever have to serve that time. If you don't, then we'll be back here, though, and there won't be any real good reason at that point why the court shouldn't impose the jail time. So I hope that you do follow through and that you comply. And based on what I've read in the report, I expect that you will. Based on so the court is going to place you on probation for a period of 12 months. The court is going to adopt all the terms and conditions listed here in the report as the terms and conditions of your probation. The court is going to impose, as to each charge, 6 months in the Otsego County Jail. You do have credit for 1 day served. The court is going to hold that time in abeyance to be served at the discretion of the court. The court is going to order $460 in restitution that's payable to the Otsego County Clerk to be dispersed to family fare. A crime victims assessment of $130, a $30 supervision fee, $325 in court costs, a DNA testing fee of $60, and $136 state costs. The court is not making the probation pursuant to 7411. Mr. Blumberg, I'll just set a 30-day time limit on a submission of a brief. Mr. Rolla, you're free to file a request, any brief if you want.
Very good, Your Honor. Thank you.
And then the court will give a written ruling based on those submissions. You do have the ability to seek an appeal of the sentence, and Mr. Lumber, do you have those appellate
I
rights?
do.
Yes.
To reflect that my client is the date and acknowledge receipt of the notice of the right to appellate review.
Thank you. Mr. Rolla, anything further we need to address?
Not in this case, thank you, Your Honor.
Ms. Willie, just make sure you meet with Ms. Davis here before you leave court today,
Yes, sir.
and good luck to you going forward.
Thank you.
Thank you, Judge.
No, yeah, let me.
All right, Ms. Jones, are you able to hear me okay? On record in People versus Paulette Jones, file number 256900. The record should reflect Ms. Jones is present today by video. If I could have both counsel put your appearances on.
Thank you, Your Honor. For the record, Michael.
Larry Brown on behalf of Paulette Jones.
All right, and Mr. Brown, I just have one second. Okay, we're on the record today for a hearing in file number 256900. We currently have a jury trial set for Wednesday, February 25th. Today is the date for the final status conference in this case. And also the plea cutoff. Mr. Brown, have you had a chance to talk to your client about the plea cutoff in this case?
I have, Your Honor, in all candor to the court, it has been a little bit sporadic. I was going through my notes a few days ago. I know she's been in and out of rehabs and things like that. I have several different phone numbers. I believe that I reached out to Jessica Van Wolfen, and she did not have an updated phone number. I did update her today with the new phone number. Miss Jones was in a car accident. I believe she was hit by a truck. She reached out to me a few days ago and gave me this new phone number. I believe she thought that the hearing actually was tomorrow. That is a reason she couldn't be here today. She has special needs when she's traveling. I did send some information to the court. That is all that she had sent me. She sent me a picture of an x-ray. I have not had an opportunity to get that to the court. I did advise her we do have a jury trial that is obviously going to have to be in person, and it is going to be an all-day thing. I spoke to her. I don't know how the court's docket works as far as scheduling. If there's another stack trial, at this point, she is due for other orthopedic surgeries coming up in March. I'm not exactly sure when. She might be able to elaborate a little bit on that.
Yes, my next,
Hold on, Paulette.
Sorry.
And again, I just haven't had a lot of contact with her for the reasons I've stated. But if the court is willing to adjourn the trial, I talked about her speedy trial rights and all of those things. I think she would be requesting adjournment, especially if the court has stacked trials.
All right, Ms. Jones, what did you want to say?
Yeah, I thought he wanted me to elaborate. My next date for orthopedic is on March 16th. And I am currently downstate because I was hit down here. I was on foot. And I have several surgeries scheduled. I still have to get my septum and orbital wall and my mandible taken care of.
Okay. Mr. Rowland.
Judge, we have another trial also scheduled on the day. That's Thompson, I believe, if memory serves me correctly. As far as I know, that's still going as well, so we wouldn't likely be losing a court date. And as long as the defendant is willing to waive speedy trial rights as an appellate issue on the record, people don't necessarily have an objection. We leave that with the discretion of the court.
Okay, Mr. Brown, I want to check on something here real quick, so I'm just gonna go off the record for just a minute.
Yes, Your Honor.
Okay. We're back on the record. So, Mr. Brown, I did check with my office. The other trial that's set for that date is older, so that one has priority. So we would have to adjourn this trial date anyway on the 25th. So the court will reset it for a one-day jury trial at the next available date following the 25th. And Ms. Jones, we're going to need you to give us a current address. We still have an address for you here in Gaylord. So if you have a different address, or are you still getting mail at your Gaylord address?
Yeah, I still reside there. I'm ambulatory only for medical transport because my leg, I cannot fold it. So I still reside there. I still get mail there.
Okay. All right, so that's where we're going to send notices. Mr. Brown also set it for a final status conference again, just as we would typically do prior to the trial date. And we'll go forward in that regard. Ms. Jones and Mr. Brown, I mean, to the extent, Ms. Jones, that you're going to be asking for any further adjournments for medical reasons, then you're going to need to provide documentation of that from your doctor. So I just want to give you that warning. I'm not gonna, if we didn't have a trial already scheduled for that date, I wouldn't be adjourning this without that medical documentation. So I'm just gonna give you a warning. I'm gonna need more than you just telling me that you can't make it, all right?
Yeah, I did send Larry a couple of things. But yes, sir.
The other thing, Ms. Jones, is you have another case that you're on probation for here. It's file number 246775, and there's been a bench warrant issued for your arrest in that file for absconding. So you need to get,
Okay, go ahead. I'm sorry.
you're going to need to get a hold of your probation agent to see if you can work that out. Are you the supervising agent? You're going to have to get a hold of Miss Davis to see if you can work something out, because right now, if you encounter law enforcement, you're going to be arrested and brought here to Otsego County.
Yes, sir. Could I get Danielle's? I thought my probation was transferred to here with Agent Kennedy, and I have sent Agent Kennedy several text messages, left her some messages, as well as my husband, and we've been in contact with his parole officer and made them aware as well. And without a response from Agent Kennedy, and I do have proof text documentation.
All right, Miss Davis.
She never reported down there. They would not open the door to their home. Vehicles were in the driveway. So she was returned to Otsego County and failed to comply with anything with me. For the warrant.
Okay.
I had
Did you hear that?
I had the home visit with the I'll have to contact Macomb County because I did have the home visit.
Well, the information we have is that that never occurred, and so your agent is still Miss Davis now, right?
Correct.
Okay, so you shouldn't be contacting anybody else. You need to contact Miss Davis.
Okay.
Your
Yeah.
Honor, if does Miss Davis have her updated contact information?
I don't know, but I think Miss Davis has exhausted efforts, and she's not going to keep chasing after Miss Jones. Right now, it's Miss Jones's obligation to get in touch with her agent.
I will contact her. I will contact her today. She's available, sir.
Okay. Okay, Mr. Brown, anything further today?
Nothing further for today, Your Honor. Thank you.
Mr. Rolla?
All right, thank you.
Okay. All right, that's all for today. And Mr. Brown, did you have any other files today?
Those were my only two, Your Honor.
Okay, you're free to disconnect at this time. Thank you.
Thank you.
Thank you, Judge.
Mr. Dick, were you ready with Mr. Cox's case?
Yes, Your Honor.
Okay. Court calls People versus Cox, file number 256932.
Record John, I called that to people.
James Dick on behalf of Mr. Cox, who is standing to my right, Your Honor.
All right. Counsel, can you tell me the status of this file here today?
Yes, Your Honor. Mr. Cox would like to accept the plea offer that's been extended by the prosecution. That would be a plea to an added count to failure to return rental property 200 to 1,000, or sorry, greater than 200 but less than 1,000, with restitution amount of $2,632.91. That is supposed to be paid full at or before sentencing. However, we would be requesting a period of adjournment of the sentencing to allow to repay it.
What is the maximum penalty for the lower charge?
The lower charge is 1 year misdemeanor.
How much is the amount of restitution?
$2,632.91.
Okay, Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge. We put it on the record several times. Thank you.
Okay. Mr. Cox, have you had an adequate opportunity to speak to your attorney about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Cox, are you on any kind of probation or parole?
I'm on a delayed sentence out of Mount Mertz County.
Okay. And are they aware that you're going to be entering this plea here today?
I didn't know if I had to get a hold of them or contact them or.
I'm sure they're probably going to want to know if you're getting guilty to a different charge somewhere else, if you're on a delay of sentence. I'm sure not being convicted of other crimes is probably a term of your delay.
Your Honor, my apologies. I picked up this case approximately, it was a reassignment approximately 2 weeks ago. I just found out about what was just mentioned, and I would like if the court would extend me about 2 minutes just to speak.
Sure.
Him
Yeah.
prior to this.
Absolutely.
No. Next week. 2632.9. And added count to failure to return rental property over 200 for less than 1,000 takes the judgment second. All right.
So dismissing count one.
Dismissing count one, pleading count two, restitution, in full at 8%. 1 year.
My apologies, Your Honor.
Okay.
Your Honor, Mr. Cox, he's not sure if he's presently on any sort of probation. He was previously put on a delay, apparently out of Montmorency. I'm sorry. I don't know the specific status of that or
Okay.
his timeline of that case.
Okay.
However, it appears that he was entered on that case before he was charged with this offense.
Okay. All right. Well, Mr. Cox, not knowing the status, and you're saying you don't know?
I don't report or anything. I just go into the courthouse every month and pay my fines.
Okay. Well, I guess you need to understand that if by entering this plea, you're going to violate whatever it is you're on there. And it's a little concerning to me that you don't know what's going on with your case over there. It seems like you would really want to know what was happening and what your status was. That's interesting. But that aside, you need to understand that by entering this plea, if that means that you're going to violate that, then you could face some additional penalties there. Do you understand that?
Yes.
Okay. And the maximum possible penalty for the charge in this case is up to 1 year in jail. Do you understand that? I'm sorry.
Yes, sir.
Okay. With that in mind, what is your plea to that charge here today?
Guilty.
Well, I don't want you to guess. I need to know what your plea that you're going to enter is today.
Guilty.
Okay. So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. and the right to testify at a trial yourself if you want it. Mr. Rolla, do you really need to do that right now?
I'm sorry, Judge.
Standing right in front of me, I'm trying to have this colloquy with the defendant. And then you're talking on top of it. Mr. Cox, do you understand all those rights that I've just stated to you?
Yes, sir.
And do you understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Okay. Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
The information I have indicates that this happened back on July 18th of 2025. Is that the correct date?
As far as I understand,
Do you have any reason to doubt that date?
that's what's in the police report. At the time, I was in the hospital and in jail.
Okay. At some point, did you rent a 2024 GMC Terrain?
I had an insurance rental from Liberty Mutual because I was in a car accident back in May 19th.
Okay. Did you take a possession of a car like that as a rental?
Yeah, I picked it up on the 1st of June
Okay.
and I went to jail on June 3rd.
How long did you have that vehicle for then? 2 days?
When I was arrested, I was at home and the rental car keys were in my pocket and they took them out and handed them to my boyfriend. And I was arrested then and I didn't get out until July 30th.
Mr. Dick, I'm gonna need a little bit of help if you can.
Yes. So on June 1st, you said you picked up the rental vehicle from Enterprise. At that time, did you know that that car was your responsibility?
Yes.
And at the time you were arrested, did that have anything to do with this case? When you were arrested?
No.
Okay. So at the time you were arrested, you were still aware that you were responsible for the vehicle? And did you make any efforts to return that vehicle?
When the cops gave my boyfriend the keys, I asked him to take it back on Monday since I was going to jail, and he never did. And I didn't have any money on my books or anything when I was in jail to make any phone calls out.
While in jail, on whatever the other case was, at any point, did you have an opportunity to use a telephone? And you could have perhaps called the department.
Didn't have any money on my account to call.
At any point, though, were you able to use a telephone during your time, your period of incarceration?
No, I had no way of calling anybody.
So you had mentioned that you were in jail and in the hospital. So you were out of jail at some point?
Or released on the 21st and put in the hospital.
Were you able to use the telephone at the hospital?
I had the hospital phone, but I don't have anybody's phone number. Okay. And when I called my best friend, she told me this the rental car was already picked up.
All right, I think I got a handle on this. Thank you for those extra questions. So either way, Mr. Cox, that rental car was supposed to be returned on June 28th, but you didn't either yourself or through someone else get it returned by that time. Is that correct?
Yes, sir. I take full responsibility. The contract was in my name.
All right, I think that fits under the willful neglect part of the statute. Mr. Rolla, would you agree?
I have no objection to that. I have a question I would like to ask before the commission. Mr. Cox, the vehicle in question, that was a 2024 GMC Terrain, correct? Yes, sir. And you don't doubt that it had a value in excess of $200?
No,
Because it was blue booked at about $18,000. Correct, sir?
I don't know the actual blue book, but it was probably. It was
Very good, Judge. Thank you.
Okay, all right. Counselor, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people. Thank you.
Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Yes, you have, Your Honor.
All right. Mr. Cox, the court finds that your plea is knowing, voluntary, and accurate. I am satisfied based on your testimony and the circumstances here that there is an adequate factual basis to support a finding that you are guilty of this lesser charge. The court will accept your guilty plea. Mr. Dick, how much time did you want to ask for sentencing in this case?
Well, Your Honor, I would ask if the court would be willing to extend 90 days. There. If it's necessary, Mr. Cox does have some personal items that he intends to sell. And he cannot otherwise come up with the money, so he wants to make sure that he's not going to show up here 30 or 60 days from now and not have this full pay. As you mentioned, he does want to take full responsibility, so that's why we ask for 90.
Thank you, Mr. Rolla.
We'll leave that to the court's discretion.
All right. This case was found over relatively recently. We've got a plea here at, I believe, the first hearing since found over. So the court's willing to allow a little extra time for sentencing in this case. We'll set this matter for sentencing in 90 days. So Mr. Cox, you need to make sure that you get that amount of restitution, which again, Mr. Rolla is $2,632.91.
Correct, John.
Okay. Make sure that you get that paid prior to that sentencing date and that the prosecutor's office has proof that you've made that payment. Okay. Do you have any questions about that?
No.
Okay. Mr. Dick, anything further on this file today?
No, Your Honor, thank you very much.
Mr. Rolla?
Just one thing, I misstated the actual pack on the record. It's actually 750-362-848, not 848. I'll be providing that information.
Okay, thank you. That's all for today, Mr. Cox. Mr. Matthew, we don't have your attorney signed in yet, but as soon as your attorney's signed in, we'll proceed with the hearing in your case. So I'm just going to leave you connected for right now. And we'll take a brief adjournment. And again, as soon as Ms. Hogaboom is connected, we'll proceed with that case.
All right.
Okay, we'll go on the record in People versus Jonathan Michael Matthew, file number 195787. If I could have counsel put your appearances on.
Can you recommend all the people?
Good afternoon. Diane K. Huggleboom on behalf of Mr. Matthew.
Thank you. This is set today for a hearing on Mr. Matthew's motion for a new trial. Ms. Huggleboom, anything you wanted to state for the record in support of your motion by way of oral argument?
No, Your Honor, I would just respectfully rely on the brief in this matter. Thank you.
Thank you. Mr. Rolla, anything from your side?
Judge, you've got the facts, you've got the briefs. I know the court, I'm sure the court's read them. If you have, then I think it's pretty clear in this particular case that the verdict was not against the great weight of the evidence. This court's well aware the victim's testimony alone can be sufficient. And in this particular case, that was corroborated by Destiny Hooper, H-O-P-E-R, Stephen DeMassey, Mrs. Miller, the same notes Ms. Sykes, as well as her reports and the photographs thereof. Thank you.
Thank you. Ms. Huggleboom, anything you wanted to say in response?
No, thank you, Your Honor.
Okay, I did have a chance to review the defendant's motion and brief in support of that, as well as the people's response and their objection and motion brief in response. I also had an opportunity to review the file generally. I did preside over this case at trial. And so I'm familiar with the facts and the testimony that were entered, as well as the instructions that were provided to the jury. This motion is before the court pursuant to MCR 7.211 as a motion for new trial on remand from the Court of Appeals. The court reviews this motion under MCR 6.431, which provides that a defendant can move for a new trial on any grounds that would support appellate relief, or because the verdict resulted in a miscarriage of justice. Whether or not to grant a new trial on either of those bases is a matter that's within the discretion of the court. In this case, the argument is that the verdict was against the great weight of the evidence, and that the jury gave undue weight to that evidence in spite of the court's limiting instruction to the jury. So where there's an argument that the verdict was against the great weight of evidence, the court can make a finding that the verdict then resulted in a miscarriage of justice and grant a new trial under 6.431. Under People versus Lemon, 456, Mish 625, 1998, in a motion for new trial based on an argument that the verdict was against the great weight of the evidence, the court is not to sit as a 13th juror or to second guess the jury. The court should only grant a new trial on that basis if the evidence so heavily preponderates against the verdict of guilty that it would be a miscarriage of justice to allow it to stand. Where the guilty verdict is based on issues of credibility, in other words, he said, she said kind of situations as what we had in this case, courts generally will show deference to the fact finder. Even some conflicting evidence or testimony is not enough necessarily to overturn the verdict. And so in this case, again, the court did review all the evidence. The court finds that that the testimony in this case was in that he said, she said kind of nature, that the jury largely had to rely, again, particularly in this case, on the alleged victim's testimony. And so the court finds that where determinations of credibility had been made by the fact finder, unless that testimony was so clearly conflicting with other evidence in the case, the court does not find that it should sit as a 13th juror and second guess the jury's verdict. Also, in terms of the court's limiting instruction, case law is well settled that juries are presumed to follow the instructions of the court, and that burden is on the defendant to show that the jury didn't follow the instructions or that they gave some undue weight. In this case, although that testimony certainly was damaging to the defendant's case, the court has no reason, and nothing's been brought forward by the defendant to show that the jury did not follow the limiting instruction and somehow gave undue weight to the other act's evidence in this case. So for all those reasons, the court finds that the defense has not met its burden of showing that the verdict was against the great weight of the evidence, or that the jury gave undue weight to other acts' evidence in this case. And the court finds that the motion for new trial must be denied. And Ms. Hogeboom, if you would please prepare an order that reflects the ruling of the court today and submit that to the court for signing.
Absolutely, Your Honor.
Thank you, Mr. Rolla. Anything else we need to address for the record today?
Not specific to this case, but Judge, it's a matter, I've already signed the other proposed order. Thank you. I did receive the counsel and we've sent it back to filing. Thank you. Other than that, nothing further.
Thank you. Ms. Hogeboom, that's all for today. You're free to disconnect. And Mr. Matthew, the court's going to disconnect from your case as well, or your site as well. And this concludes the court's afternoon docket.